All right. Got some people trickling in here from the waiting room. Just give a second for those numbers to get to what I saw in the waiting room here. Almost there. All right. Looks like we're about at capacity so far from what I saw. Well, welcome everyone. Good morning. I want to thank you guys for taking the time to attend this webinar. So as you've seen in our email communication, and may know from the industry, law changes are coming on January 1st of 2025 to California Government Code 4216. So in order to keep you guys up to date, make sure we're all staying in compliance, we want to offer this webinar here just to formally communicate these changes and also give you guys the opportunity to ask any questions to clarify any of these changes that are going to be affecting you guys next year. But I'm personally excited, really excited for some of these changes. I think it's going to make the process a lot easier, a lot more efficient for you as excavators, which is all around a good thing, right? We want to make this process as easy as possible. So I'm glad the lawmakers made efforts to do that very thing. Just one note, one quick housekeeping item. So during this webinar, you will have the opportunity to ask questions if you have some. The way that you're going to do that is at the bottom of your screen, you'll see the Q&A button. That's going to open up the Q&A window where you'll be able to type in a question. And we have a team of panelists from our staff who are on today's webinar, and they are looking at that Q&A the entire time. So they're going to see your questions come in, and they'll be able to answer those directly to you to provide instant feedback while we are presenting the changes to excavation law. And of course, once our presentation's over, if there's any additional questions, we can take some time to answer those on the call together. But just know that the Q&A button is the area where you want to ask questions. There is also the chat window. Please don't use this to ask questions, as we are not going to be monitoring it that closely during this call. But in the chat window is a link to a page on our website that will include documentation from the California Facilities Underground Safety Board that details all of the changes to California law in an organized way. So that's something that I'd recommend you guys checking out, downloading, and keeping for your records. You'll also see some registration links for our future webinars. So we are doing 2 more webinars next Thursday and the Thursday after, in case this conflicted with anyone's schedule. So if you know anyone that maybe was registered that couldn't make it, go ahead and let them know we have 2 others that they can sign up for. I just got my first question here. Looks like Ryan's typing the answer, but I'll answer it live. Someone asked where the link was. So that's going to be in the chat window. So on the bottom of your screen, make sure to click that chat button. Should open up the chat window, and I will actually just go ahead and resend it just in case. Oh, chat is disabled. Oh boy. Okay, that is an update here. Let me see if I can enable this real quick. Apologize for that. I thought we had chat available for everybody. Okay, let's see. I changed the chat settings to everyone. Hopefully you should all see the chat button now. There we go. Seeing some people respond. Perfect. Okay, and then the links are in there. Feel free to use that link, and we'll get started. So, Nate, let's go to the next slide. All right, so just a quick summary and outline of what we're going to be talking about today. So, as mentioned before, all changes to California law are going to be starting on January 1st of 2025. So, coming up quick. Part of these changes is going to be clarifying the term response or respond in relation to an operator's response to an 811 ticket. So there's a few codes that pertains to. We'll go in depth on those and what that means. Also, excavation begins when responses are in. This is the super exciting one. I'm actually really pumped for. So we'll talk more about that, what that means for you as excavators. Vacuum objections are going to be required through EPR. We'll show you what that looks like as well. There's also now 1 day or 1 working day rule for undiscovered utilities. We'll go into more detail on what that means, as well as some updates to damages. Okay, so when to call 911, when to call 811. And then there's also some additions regarding local agencies and fees, and approximate location is now clearly defined. Again, one of those ones I really appreciate. So let's get into it. Let's go to the next slide here. All right, and then Nate, you want to go ahead and introduce this one for us?
Yep, so going to the first slide here, this is clarifying respond within the Governmental Code 4216. Listed there are the affected sections as part of this defining of what respond or response is within the code. It was very broad, in the term response. So it's now clearly defined on what that actually means. If we go to the next one here, the first one that deals with this update is 4216E. This is for the operators regarding electronic positive response. The response from the operator to the regional notification center or to the ticket itself. It's the response to the response. Basically, this is stating that regarding the EPR that must provide their status as a statutorily required response to a ticket. It basically goes back and is clearly defined in section 4216.3A1A. If you're not familiar with that, we'll get to the actual 3 legal ways that the operator can respond. And basically, this is just stating that it is defined in the response is defined within those 3 ways.
Nate, can you go back to the first slide real quick? Or the one before this. Yeah, perfect. So yeah, and just to clarify Nate's point, so that term response is used specifically in these 3 codes. And what we've noticed just at the center is that sometimes that term response creates a little bit of confusion as to what counts as a response from the operator. So the lawmakers have actually not changed necessarily, but they've clarified that word and expanded it to refer to the duties listed in 4216.3A1A, which, as Nate said, we'll go ahead and unpack that, but something we're all familiar with practically, but just to get us summarized on the same thing. So go to the next one again, Nate. So this code specifically, this is the definition of what electronic positive response is, right? So previously, it listed that an electronic positive response meant a response from the operator to us at the notification center, providing the status of an operator's statutorily required response to a ticket, right? There's that word response. So the lawmakers have clarified what that word response really means. And it's notifying us about the status of their obligations, their required responses, according to this code that they reference, 4216.3A1A. And so the next code on the next slide, which deals with the time frame, right? How long utilities have to respond, now gives us clarity on what type of response to expect, right? These are the responses that you must receive, and this is the time frame that operators have. So they have until the legal excavation start date and time to provide one of these required responses under 4216.3A1A. So just to clarify, this term response being just more clarified for you, for us to understand that these are the required responses that we should expect from utility operators. And then, let's start with go ahead with the next one, Nate, that talks about the fact that we have to receive all those responses before starting.
All right, yeah, so this makes clear that the excavator must wait to begin excavation until the operators on their ticket have fulfilled their duties listed on 4216.3A1A. So once they have responded in one of those 3 ways, then they are able to start excavation at the job site.
And then next. Yeah,
right,
so this.
So Oh, go ahead, Matt.
Sorry, so this is the actual code, right? This is the code that the lawmakers are now referring to. Some of you may not be familiar with the specific code, but this is something I think all excavators in the state are familiar with. This is the typical responses you get from utility operators, right? So law requires that an operator respond to an 811 ticket in one of three ways. So the first way, if you go to the next one here, is locating and field marking, right? We see the marks on the road, we see the marks at our excavation site, the lines are marked in the appropriate color. They include the width of the facility, they include the company name who left those marks. That's the first required method that they can choose to respond to your ticket. The second one is they can provide information to you, right? They can notify you about where their lines are located with maps, with, as-built, with GIS data, with an email. That's the second response they have available to them as they're responding to your ticket. And then the third is a no conflict, right? A clear no conflict. So an operator can communicate to you that they do not own or operate a line within the area of excavation. So the law is just expanding and clarifying this word response to simply say that when we say response in those specific sections, we mean these three required responses, right? So operators have until the legal start date and time on the ticket to respond in one of those three ways, and excavators cannot begin digging until they receive one of these three responses from all operators on their ticket. Again, nothing's changing operationally. This has been in place for years. It's just clarifying something that we all already do. So just kind of one of those little editorial changes to just clean things up. And then the next one, this is one, we can go ahead, we summarize this, so we can go to the next one here. So the next one, this is the exciting one, something I think is going to benefit all excavators in the state. So the new language has been added into the law, into 4216.2 G2. And simply put, this allows you as an excavator to begin digging as soon as you receive all of those required responses from the operators on your ticket, right? Even if your start date and time has not passed. So for instance, if you submit a 2-workday ticket, right, and all the operators respond in one of those three required ways, maybe within a day, the law now allows you to start digging instead of waiting for that 2-workday period to pass. And again, this is starting January 1st. So currently you're going to need to wait until your legal start date and time passes, but on Jan 1, this goes into effect. So I think this is going to be extremely helpful for excavators in the field, really speed things up, avoid downtime. Personally, I thought it made a ton of sense to change this, right? Just for everyone involved. So make sure to confirm that you've received one of those three responses before you start digging, but just know Jan 1, as long as you got those responses in, you're good to go. And then, yeah, Nate, go ahead on this one.
All right, so this is regarding expired tickets. So for whatever reason, if your ticket has expired and you have to create another ticket, this is removing the 2-working-day part out of how the code currently stands. So this is just kind of reiterating the fact that you no longer have to wait the full 2 working days to begin excavation. It goes directly back to the 4216.3A1A. So as soon as the operators fulfill their duties with one of those 3 legal ways to respond, you can begin excavation. We also want to make a point that within our ticket entry system, we do have a copy function. So if ever you do have an expired ticket, you could bring that ticket back up, hit the copy, and keep all the information to make it a little bit more easy transition to create a new ticket.
Yeah, that's like greatly said, Nate, perfectly said. So yeah, as you all know, currently when tickets expire, the law requires you to stop excavating and essentially submit a new ticket, right? So the law is just clarifying and removing the requirement to wait that 2-workday period in the case that your ticket expires, and essentially doing the same thing that we mentioned earlier, right? Just as long as you get those responses in, you can start up again. And as Nate mentioned, that copy feature is really helpful. If you have expired tickets, brings all the information over onto the new ticket. You'll just have to, confirm the mapping, confirm the location, and then you can submit it. So another feature I think is going to be really helpful for you guys.
And just a little caveat, the way the amended section it works on this slide, if you're trying to read it, basically everything that is in red has been removed from the code starting January 1st, and everything in blue has been added and is now moving forward after January 1st is the way the code's going to read moving forward. All right, so this one, vacuum excavation equipment. This is kind of a new thing. So this basically this is for the operators that are currently in the webinar here. Basically, as you know, when you do submit an excavation ticket, there is a section where vacuum excavation, if you for any reason you feel that you're going to be using vacuum excavation equipment, you want to put that on your ticket. This is for the operators, in which case, if for whatever reason the operator is denying the use of vacuum excavation equipment around the facilities, they must in turn put that into their electronic positive response to put it on the ticket itself. Do you want to add something to that, Matt?
No, that's perfect. Yeah. So still vacuum requirement still exists. You're going to have to notify the operator and wait for their clearance to use vacuum equipment around their lines. As Nate said, if they just deny that request, they are now required to include that on EPR. And Nate's going to show what that looks like, because we don't currently have an EPR code specifically for that, but we do have a way to make that note available.
Right. So here's our damage prevention portal that is offered to all of our utility operators for free, kind of giving you a little view of what it could look like. So basically, this is a response code from the operator to the excavator stating that they located their area and marked out all their facilities. And the way it works within DPP, there's a little note section at the bottom, and currently you would just put, if you do not want vacuum equipment used around your facilities, just add a little note saying, vacuum equipment is not authorized for use. Of course, there's tons of operators that use certain ticket management systems and may not look like this particular model. But we recommend you reach out to your vendor, reach out to your TMS vendor, and let them know about the situation that's going to be occurring come January 1st, so you can get that all dialed in before that date. Yeah.
And one other quick note, just make sure you'll see that little check box below the notes box there for any operators on the call. For notes that you want visible to the excavator and included on their EPR in OCA, the ticket entry platform, make sure you check that box so they can see that note, right? So the whole point is they got to see that note on EPR to confirm that the vacuum's not allowed at the site.
All right. We also give you an example of the operator side. If you log into your one call access account, we showed you where if you look into that response from that particular operator, it is listed right there. So they put the 010 code stating that they locate and the area is marked, all the facilities are marked at the site, and the notes are listed there. Vacuum equipment is not authorized for use. So that's from the excavator standpoint, that's where you could see that note come in to the system.
Correct. And then one other note for excavators, if you are using a TMS, you'll want to just clarify with your vendor to make sure these notes are coming through and speak to them about how that's displayed. But worst case scenario, you can always log into your OCA account to look at any ticket. And you just simply click on the ticket in your history, and then in the confirmation screen, what you're seeing here, you can click on the member specifically, and then it should show that note with their EPR response. But definitely reach out to your web TMS provider, ensure that that's coming through for them. Hopefully make that easier and more streamlined for you for the web TMS users in the room.
All right, so we're moving on to one-day rule for undiscovered utilities. So this has been added to the law, basically stating for whatever reason, if an excavator at the site is having trouble locating a facility, if they're trying to daylight something, expose underground line, and they're not finding it, for whatever reason, the excavator could reach out to the operator directly. And there's now a time frame for the operator to respond. So this is built into the law now. So the operator shall provide relevant information to the line in question within 1 working day. Uh, yeah, so it's pretty much straightforward. As soon as that message is sent out to the operator, you have within 1 working day to respond to the excavator or the site itself.
Yep. And I like this one too. I think it adds a lot more rigidity and clarity for the excavator to when to expect that additional info. So if you do run into undiscovered lines, or you potholed, you try to hand dig and expose a line that you can't find, you've got to, of course, make sure to notify the operator. So contact them directly or contact us at the center so we can put a note on your ticket. Because if the operator does not know about that, then the 1 working day doesn't really apply, right? We got to notify them so you can get that 1 working day window to get more information. But this is another one I'm actually really pleased to see. I think it'll help everyone.
All right, so going into update damages, call 911 first. So the way it currently stands with this, it didn't really lay out the fact that currently it doesn't lay out the fact of what level you call 911. If we've received calls all the time where something has been damaged, and basically it's just clarifying the need to call 911 in certain circumstances. So if you damage any escape of any flammable, any toxic, or any corrosive gas or liquid, or any type of high priority line, the amended section is now stating that you must immediately call 911 first before you do anything else. Whether you call the operator, you call us. If for whatever reason, if you damage anything really nasty, you must call 911 first.
Yeah, so the requirement on when to call 911 as an excavator is the same, right? So if, like Nate said, if you damage a gas or liquid pipeline and product is essentially escaping, or if it's a high priority line of any kind, whether or not product is escaping, that's a 911 situation. So we've had instances at the center where that's happened, and people are contacting us first. And that's obviously not a safe scenario, right? We want to make sure to get emergency services out there as soon as possible, mitigate any type of future damage or injury to the community. So now the law has a clear designation with this update that if you are required to call 911, that is now the first call that you have to make. And then after that, obviously notify the operator, and then you have 48 hours to notify the 811 center of any damage. So just keep that in mind for your operations. Pass that down to your project managers, your foreman. If that unfortunate situation happens, 911 is the first call to make.
All right, and this is there's a few, but they've also added a few caveats to call 911. So there's a few scenarios that if you fall under, and all three of these things are met, then you do not have to call 911. So, and those three things are that the excavator is the operator of the high priority subsurface installation. The damage was discovered by the operator during operations and maintenance activities, and the damage does not meet the circumstances in paragraph A. So basically, it's just stating if you fall under all three of those terms, then you do not have to call 911. So those are the three, but you must meet all three in order to not call emergency services out.
Right, exactly. So yeah, all three got to be met. And essentially this is for, the utility operators who own the line, who are doing maintenance, they hit the line that they own. And again, no product is escaping. It's not a dangerous scenario for the community, but they're the ones who own and operate the line. They're the ones who are going to have to repair it anyways. They understand, the risks involved and how it works. So just kind of allowing for, I think, common sense in that scenario where it's not a danger to the public. They can go ahead and take care of that scenario, repair the line, continue on. But that exemption exists for excavators who are the operator, right? So you have to be the operator of the line. And again, no product can escape from it. If we've got escaping product, that flammable, toxic, or corrosive liquid, then we're going to need to call 911 to have that handled.
All right, so this is conditions where an excavator does not need to call 811 if you damage a line. So pretty much kind of looks the way the 911 did. If you meet those three requirements, then you don't need to call us within the 48-hour period. It's pretty much straightforward, pretty much a mirror image of the 911. If all those requirements are met, you do not need to call the center within 48 hours. All right, local agencies and fees. Some of you may know local agencies as part of 4216.5. They're able to charge fees to kind of recoup their expenses for the 811 process for getting out there and marking and locating. This amended section is just trying to bring to light certain reasons why that may not be a good idea. Certain like B right there states the local agency that chooses to recover the costs, whether the fee deter an excavator from contacting the regional notification center. So of course we want everyone, homeowners, anybody that's excavating the ground, we don't want a deterrent to call 811 and submit a dig ticket, right? So it's just basically giving you a few different reasons that you might want to not charge fees for the 811 process and maybe fit it into like a permit fee or something of that sort, and not try to deter anybody, group or person to submitting a dig ticket.
Yeah, the unfortunate thing is they didn't, it's kind of just one of those things forcing consideration, which I think is a good step, right? Obviously, in my personal opinion, I want the 811 service to be free for everyone, but definitely understand some of the limitations for smaller organizations when they have to provide a response to a ticket. So essentially, like Nate said, this is just forcing local agencies to really consider the ramifications of charging a fee and finding alternatives, right? Hopefully packaging it into a permit fee, so they can keep the 811 process essentially free for everyone involved.
If those don't know what local agency actually means, we just put that definition. Local agency means a city and county school district or special district. So local agency, as it's said in the law, fits under those different entities. All right, this is another awesome one we think here at the center, the approximate location defined. So if you do look throughout the code 4216, you'll notice approximate location. This is just kind of clearly defining what that means. So they've basically they've used the tolerance zone and just expanded it to the approximate location as defined in the law. So the approximate location now means no more land more than 24 inches on either side of the exterior surface of the subsurface installation. So based on what is in the ground, that could, lessen and widen based on what's there. So this kind of takes out the wiggle room of mismarking and stuff like that. To mark your utilities as an approximate location is clearly defined now.
Yeah, and this is helpful too. I think this is one of the other ones I was really happy to see, because again, we at the center, we run into this more commonly when we have questions about inaccurate field marking, right? What constitutes or determines whether a mark is inaccurate, right? And currently in the law, without this definition of approximate location, it gets a little sticky at times to really determine what that means. With this addition, now it's clearly defined as 24 inches on either side of that utility. So that if anything's outside that, now it's considered inaccurate, right? Which is, I think, very good for operators and excavators to be on the same page. I think it'll be very helpful in the long run for us to understand that. So essentially, it's the same as the tolerance zone. So the line needs to be within 24 inches on either side of the exterior surface as communicated with the markings on the ground, right? So like Nate was mentioning, depending on the width of the pipe as it's marked in the field, that corridor or that area, the approximate location is going to grow or shrink potentially, right? Because you've got to factor in the total width of that utility as well. But yeah, clearly defined, which I'm all for. I love it. And I think it's going to be a great addition for excavators and operators next year.
All right.
Perfect.
And yeah, that is it. That's the end of the updates. We want to be with you on this. If you have any questions, anything pertaining to these updates, don't hesitate in reaching out to us at education@usan.org. All the complete law change information is also available on our website, as well as the documentation that Matt had provided in the chat. Look through all of it. There's a few other things on there that we didn't mention in this presentation, but we highly recommend you give that a good run through. And like I said again, feel free to reach out for any reason, for any clarification. If you have any questions, we'd be happy to help you out.
Yeah, and we'll take a minute here. I know there's a few questions in the chat. I did see one, or sorry, the Q&A panel. Keep going to the Q&A. I don't want to throw you guys off with that, but I did see one in the chat regarding the presentation slides. Is this going to be available to you after this presentation? The answer is yes. We are recording this webinar, and on that link that you received in the beginning, once this completes and we can review the webinar recording, we're going to go ahead and post it to that page, link to that. So you'll be able to go back and view it. If you want to share it with your team internally, you're more than welcome to do that as well. So yes, that will be available shortly after we review it, and I can get that posted. And then I'm just looking through the Q&A here. Let me take a look at some of these questions we've got coming in. So now that we're at the end, we'll just start answering these. Obviously, if any panelists want to jump in and talk out loud, you're more than welcome to. The first one I'm seeing here, so if we put the size of pipe on the ground, does that add the radius of the facility to the 24-inch zone on either side?
Yes.
So essentially, yes, right? So let's take, for instance, you have a 6-inch pipe, right? So the law requires that when you mark the utility, you're listing the diameter of 6 inches on the marks. The excavator has to account that 6 inches into the tolerance zone. So 24 inches is, again, measured from the outside edge of the pipe on both sides. So when we've got a 6-inch pipe, we add that to 24 inches on one side and 24 inches on the other. I got to do my math here. 24 is 48 plus 6. That's 54 total inches.
54,
which
yeah.
they have to hand dig until they expose that line, right? So essentially, the other way for the inaccurate field marking, if that pipe is outside of that 54 inches, it could be considered inaccurate on the field marking. So definitely take into account the width of the pipe as you determine the tolerance zone and determine whether it's inaccurate or not, because that will change depending on how wide the pipe or the diameter of your utility is. Let's see what else we got here. Okay.
Miles had one. Yeah, I believe Matt just pretty much answered that question. So I'm just going to say answer live for that.
Perfect. Okay. We got one more here from Kurt Rosler. So what if we find an unknown line and no one is claiming it to be theirs? Does the one-day rule come into play? That's a great question. So when we look back at that law, if you go back to that slide, Nate, the specific code essentially points to the extent that the information is available. So essentially, if no one owns it, right, there's no way they could provide additional information on that line. So this might go to some different scenario where now we're having to figure out who owns the line. Is it abandoned? And I don't personally have a clear answer on how that process works. But to answer the initial question, I think the one working day probably wouldn't come into play there because nobody is claiming line, right? Nobody is saying it's theirs. So there's no way they could provide additional information about that utility.
Yeah, with unknown lines, it's best to just reach out to the center and if there's no marking, if there's not a marking at the site, then yeah, just reach out to the center or go to One Call Access and claim that you have found an unknown line. So then we could just notify all the utility members that are relevant to the area, and we could figure out exactly who it belongs to and then go from there.
Absolutely, absolutely. All right, so I got another one from Charles White. These all go into effect January 1st, 2025 at 12:01 a.m., correct? Yes, January 1st, 2025 is the cutover date for these law changes. So that is when they go live, so to speak. So again, right around the corner. I think a New Year's Day treat for a lot of us, a lot of the excavators in the room. So be on the lookout for that, and just, yeah, get prepared. David has a question regarding some damages. So does that say if you damage cathodic protection cables or conduits, the excavator must call 911? So the requirement to call 911 is in the event that you damage a gas or liquid pipeline that results in the escape of flammable, toxic, or corrosive gas or liquid, or if you damage a high priority line of any kind. Okay. Now, damages are essentially defined as any break, gouge, leak, nick. There's a few other adjectives, sorry, that are used to describe that definition. Essentially communicating that if you hit a pipe, it's considered a damage, right? So the cathodic protection, I don't know if they put that on high priority, but if they do, then you've essentially hit the pipe. That might constitute a 911 call.
Yeah, anything over 60 PSI is considered high priority.
Correct.
Yeah, so yeah, I don't, yeah.
Ryan, did you want to, I saw you unmute. Were you going to jump in on this one?
I was just going to say that at a minimum, like usually the requirement to contact 911 is regarding the escape of product. But at a minimum, the cathodic, anytime you basically touch a facility, whether it's just barely touching the cathodic protection, the wrapping or the coating or anything like that with like a bucket or a shovel or whatever you might be using, at a minimum, you should be notifying the utility that that occurred. Because if the wrap or the cathodic protection and those items get damaged even at a minor amount, it creates a point at which the pipe can start suffering future issues, basically. So there could be what's the word I'm looking for? Sorry, but
it compromises the integrity of the line.
It compromises the integrity of the pipe. It allows minerals and other items to pierce the wrapping, basically to get to the bare metal of that facility, which could compromise it in the future. There have been utility issues with that across the nation before, where there was a damaged line where they scraped off the protective coating but didn't actually damage the facility. But then over time, as that corrodes, it weakens that point in the facility, and then that could lead to an issue down the line. So you should, at a minimum, always notify the utility that there was a scrape, or you touched it, or you ripped it, or you damaged the coating, so that they can go out and repair that section so it doesn't lead to a corrosive issue in the future and a weakening point of that facility.
Right. And to clarify too, the law does require any damage, right? For you to notify the operator. So, and also 811 within 48 hours, right? The 911 is elevated for, like Ryan said, escaping products, if it's a high priority of any kind. But essentially, if you hit a line, you got to call the operator directly every time and notify 811. And then obviously, if you're the operator of that line, and then all those other conditions we mentioned earlier are met, you may be exempt from calling 911 and the 811 center respectively. One other question I got from David here. So in the slides, I may not understand the amend section. So Nate, can you go back to one of the law change slides? This one's good. So just to clarify, and this was taken pretty much directly from the California Underground Facilities Safe Excavation Board's website. They provided a document that clearly outlined all of the changes. So on the left is a simple summary of the change. On the right is the actual section of law that's being amended. And then obviously in red is anything that's being removed or redacted. And then blue is anything that's being added to that section itself. So that's how you would read through this. It gets a little convoluted at times for some of these extensive ones. So, but that's essentially how you would interpret this PowerPoint.
Right. So if anything in black and you're reading everything in red, how it currently stands. And then anything in black and just reading the blue, that's how it's going to stand after January 1st.
Perfect. And yeah, it looks like we got a few others coming in here. So Miles, just to confirm, an inaccurate mark is outside the 24-inch plus the diameter of the line. not radius. So yes, essentially if the line itself is located outside that 24 inches from the outside edge of that pipe on either side, the law defines that as an inaccurate field marking. And then Charles has a question about literature. So does the call center have a scheduled update for updated literature? So I assume you're referring to our excavation manuals. The answer is yes. We are currently working on updating those and getting them printed. We're hoping to have those ready to go in January. Obviously, we are dependent on our vendor on what turnaround time they're going to be able to provide on the printing of those manuals, but we are working on that now. So we should have updated manuals that reflect these law changes starting next year. Got some more questions. Great. Okay, so Bill here. So up in Eureka, where we are located, the county is not a member of USA. Unfortunately, creates problems. Do not mark them. Is
Gravity
going to
fed.
become law that all utilities with underground utilities like culverts become members. So currently in California law, any utility operator is required to be a member of the state. Now, I say that cautiously because in the definition of utility operator, they are defined as, basically an organization that owns or operates a subsurface installation. So that's the key word here, subsurface installation. The law now defines subsurface installation as essentially any line except non-pressurized sewer or storm drain lines, okay? So there are instances where utility organizations exclusively own non-pressurized and storm drain lines and thus are not considered utility operators or operators in the law. So with that logic, they are not necessarily required to be part of 811. Now, I'm not sure what the deal is with your specific county, what they own or operate. If they do own or operate another line, they potentially would have to be members. But what I would recommend is reaching out to our member services team. And then obviously if we need, we're more than glad to talk to the county directly to see what's going on and see if we can maybe, educate them if they need to be members or not. But that's a bit of a nuanced question. So I definitely recommend reaching out to member services. I will type their email in the chat below and definitely give them an email and then they should be able to help you out a little further. Make sure I spelled it right. Member services. All right, there you go. Just sent it.
I'll do this one here. Anonymous attendee. If the excavation is entirely in private property, some operators won't mark. What do we do in this situation if they won't submit a response? Yeah, so with the members or the utility operators, they're supposed to mark out anything that they own and operate. So if they don't own the line that is on the private property, then they do not mark that. In this case, we'd suggest getting a private locator for any private lines. We get calls like this all the time at the center where they're trying to mark out, the water line that goes from the house to the spa or something like that. So we just deal with the utility operator side. If there is a private line that was put in by, some contractor back in the day, the utility operator is going to have no knowledge of the route of that particular line. So in that case, we highly recommend you getting a private locator to mark out those lines for you. But the utility operator,
No, I was just going to clarify, Nate. You said it perfectly, but just to add some more color to that. So the law requires the operators of utilities to mark anything that they own and operate. Exactly what Nate said. But some, and this varies by the utility. Water is known to have their meter at the curb or in the street, and then a private line goes from, onto the property to the house. Now, natural gas is different. The meter runs all the way to the structure. So they're going to mark even if it's on property because they own and operate it. So it really depends on the utility. But you just never know. You never want to take that risk of just thinking that, hey, it's on private property, I'm going to dig. You don't want to do that, right?
Yeah, it's similar. The way to think about this is like to lose the thought of private property because it's not private property that matters in this situation. It's similar to like when we talk about 2 working days, but some people will say 48 hours or just 2 days, right? And so there's different ideas out there around those different things. But private property on its own, as Colin mentioned and Nate was mentioning, there are utilities that will own facilities on the private property, like the gas company where the meter is on the home, or even some other utilities that might have facilities that might be running underneath the back of the property that don't actually serve the property, but are like transmission lines going from one place to another. And so I think maybe get out of your mind the idea of private property, because that is not a real thing. It really is that they're, as Colin mentioned, they're required to mark what they own or operate at the site that you're working. And for a lot of utilities that are servicing the home, that most of the time is up to the meter, but that is not always the case with the site. So don't make that assumption when you're kind of getting ready to determine how you're going to handle your site.
Yeah, absolutely. And you can always contact the member directly to clarify their non-contact numbers on your ticket, or we can always send a note to the member on your ticket at the center. And you can clarify with them directly about the marking, if they covered it or not. And then like Nate mentioned, if the utility states that they marked up to where they own and operate the line, but there's something else there, private locators are a resource that you can use to come out and mark additional private lines.
One last thing I'll say about that, and then I'll shut up, is that we do have a new resources page that is going to be coming to our website. A common request that we've gotten from the excavating community over the years is, I need a private locator, like how do I find one? Or I need a vendor that provides this service, how do I find one? And so to help provide you guys with as much information as we can in making those calls and connecting you to people that can provide the services you need, we do have a resources page that will be going up here at the beginning of the year in January, that'll allow you to go in and see folks that have joined USAN to be a resource and to provide their information for folks that are looking for services like private utility locating. And so it'll be an easy place for you to go to kind of look for those service and options for vendors that provide the service that you need. So you can look for that kind of in January on our website for those vendors and opportunities for that.
Perfect. Yeah. And Dino, I got a question from Dino for expired tickets. So the question is essentially, if a ticket expires, right, an excavator has to stop working and is required to submit a new ticket. Does the 2 working day wait period not apply anymore? So the question is that, or the answer, pardon me, is starting Jan 1, that 2 working day required wait time will be taken out of that section. So essentially, the only thing that you need to wait for is for all those utilities to provide one of the 3 required responses on that new ticket, and then you can start up the project again. Now, again, that's starting Jan 1. So any projects you have now in December still apply to the current law, which is a guaranteed 2 workday waiting period. So if your tickets expire, you got to make a new one. You're waiting 2 workdays plus the receiving of all those utility responses to start up again. January 1 next year, that 2 workday period is being removed, and now you're just waiting for those 3 required responses.
And just to chime in on that, because we had a similar question earlier that was around expired tickets and wondering if the previous markings and positive response notifications carry over to a creation of a new ticket, and they do not with these new changes that are happening. So if your ticket expires, your ticket's dead, all the responses are dead, you can imagine that they don't exist anymore. When you will have to create a new ticket to replace that expired ticket, but you still will have to wait, as Matt noted, for new responses to that new ticket that you created. The previous responses and markings no longer apply to your new ticket. You have to wait for them to respond before you can start excavation for that new ticket. Yeah. And in light of that, we'll have to, as the question mentioned, shut down your job and wait until you get those responses. So another good reminder to be managing your tickets and not letting them expire, because it does require you to shut down the job at that site, which is costly, obviously, for our excavators in the field.
Yeah, and our operators as well. We get a lot of feedback from the operators that it can put some strain on them. So managing your tickets helps everyone in the system to be more efficient, and it clears up resources for future dig tickets. So I would recommend definitely keeping a good eye on the tickets, renewing them, not letting them expire if you do plan to continue digging.
And just another thing regarding resources, there are several companies out there that specialize in excavator ticket management. They're platforms that'll connect to our system and collect all of your tickets. You could set up alerts. You could see how things are progressing. They can also pull in the positive responses into their platform. So there's a lot of services out there that try to make this easier for you, so you don't have to necessarily have like a whiteboard in the office or an Excel spreadsheet and track everything yourself. And some of those services will be provided on our resource page in January as well for you to check out.
Absolutely, yeah.
And I'm gonna take
Go ahead,
Kat's
Colin, go ahead.
question. She says, what happens when phone numbers are not current and you cannot get a hold of operators? Unfortunately, this does happen from time to time. We have over 1,500 different utility companies, and sometimes they get bought out, numbers change, or contact numbers change. They get a new company phone number assigned to them. So anytime this happens, definitely give us a call. Our member services department, monitors this and manages all the relationships with our utility operators and what we call the member rep for that company. So if a number doesn't work, let us know. We'll contact the member rep and make sure that gets adjusted. But no, we're more than happy to help you with that. Just sometimes we don't hear back. We assume everything's good because they gave us the number, but sometimes they do become out of date. So let us know, and we'll attack that.
Yeah. Dean, we got a question here from Dino. So what happens when the excavators are not putting the site contact numbers on the USA ticket? So the easy answer is it creates problems potentially, right? We want to make sure that any excavator who's submitting an 811 ticket is putting a contact in that field that can easily answer questions about the job site and provide any additional information needed to the operator in regards to what's happening or how to access or locate the area efficiently. Unfortunately, there are scenarios where the excavator does put maybe an office staff member who maybe manages the tickets or someone who's not as familiar with the site. We don't have a way to police that, unfortunately. It's up to the excavator to provide us with the best information, but we do communicate through our education presentations. And we are making an effort to, among other things, to make aware that this contact needs to be somebody who has an acceptable level of knowledge about this specific job site and ticket. So we're working on that, but it's a tough one to police for sure, because we got to just trust the excavator to give us the appropriate contact info. All right, let's see. So we got a few trickled in here. So Miles McCall. So off topic, what are the requirements for preserving marks and required remarks? Is it true that after 28 days you need remarks? Do we need to wait for updated positive responses? So the law requires that you maintain marks during the entire duration of the project. And it states that if those marks become reasonably invisible, can't remember the exact phrase, but essentially if they become faded, if they're not reasonably visible anymore, the law requires you to stop work in that area and request remarks. Okay, now you are able to stop working in just a specific area of your job. Maybe you have a larger ticket and on one smaller section, the marking's faded and you can't reasonably determine where the line's located. You are able to stop working just in that area and request remarks. Or if obviously the entire site has marks that have faded, then you'd have to, shut down for the entire site to get those marks up again. Once you request remarks, right, you've got to wait for the utilities to respond, for that utility to remark the site, and then you can start digging again. So yes, if the markings are no longer reasonably visible, you have to stop in that area, stop excavation, submit a remark request, so our members can come back out and mark those lines, and markings need to be clearly visible for the entire duration of your excavation project.
There's a question from Dino. What is the legal work site location, the description of the USA, or the delineation in the field? So that's a great question. And essentially, what needs to happen is it's three different things. So when you're drawing when the excavator is drawing the polygon on the ticket, because that's how we notify the utility companies of the outlines and boundaries of the dig dig site. So that's one. Second one is the description in the USA should match exactly what they drew. And then third thing is the delineations are exactly with what they drew out and what they said in text. So if all three of those are aligned and exactly the same, then there should be no questions from a locator's perspective, right? Sometimes we have to explain to some excavators where they don't do a great job of filling out all the details, and they don't understand until we tell them, like, put yourself in a locator's shoes. They have to go out there and respond to this. Let's look at this ticket together. It's kind of unclear what you're saying. So it's really important that the polygon that you drew on the ticket, the written description, and the white marks, the delineation, the pre-marks in the field are all exactly the same.
Correct. Yeah. All right. So all the questions are completed. I did see one come in through the chat real quick, really regarding liability. So Dutch is essentially asking if the excavator exposes the entire tolerance zone of a marked facility but can't find it, crosses it without asking for additional info, then damages the facility outside of the tolerance zone, would the excavator be at fault? You know, Dutch, it's really difficult. It's really difficult for us to assign liability to any case because of how much nuanced information goes into determining who's at fault. So I'm unable to determine whether that would constitute you being at fault or an excavator being at fault or an operator. All I can simply say is that as an excavator, make sure you are following all the requirements listed out in 4216.3, as well as, you know, any requirements that are in the California Code of Regulations, Title 19, Division 4. And then operators as well do the same. But in a lot of cases, these liability issues take, you know, court or take lawyers or take, you know, arguments back and forth about who's at fault, involving a ton of different details about what went on at the site, when the ticket was made, and so forth. So I can't give you an answer on that. It's just really difficult to determine what that would be in that case. But all I can say is just continue to obey the law, stay in compliance with your requirements, and it should put your best foot forward, essentially, to keep you protected from liability.
Hey, Matt, it looks like we're getting some questions in the chat as well. Michelle had a question regarding multiple locations on a property, specifically for grinding stumps. Currently, you know, if you're working throughout the property, you're going to have to draw and delineate in white the entire property. But in the near future, we are upgrading our system, our platform, in one call access, where you'll be able to draw a circle around multiple locations on a property. And that way, if there is, you know, a utility line, let's say in the rear of the property, that isn't impacted, it wouldn't even pick that up on our system. And then you'll have one less utility company on your ticket. So in the near future, you will be able to draw multiple specific locations, what we're calling multi-polygon, multi-dig site polygons. We're not there yet, but it is something that is operational in other parts of the nation that we are going to upgrade to.
Yeah. I got a question here from Wayne. So is there any way to police utility companies that make up reasons for not responding on time? For example, saying there are no delineations, or knowing for a fact there are. So what we recommend to do first, before we kind of go down the policing route or regulating, is we always recommend for excavators to reach out to our utility operators, and we are more than happy to provide you with contact information, maybe even information that's not on a ticket if you're having problems reaching that number. But we always want to facilitate communication between the excavator and operator to try and clear up any confusion, clear up any issues, and just, again, make sure we're all working together towards this common goal of damage prevention. If those resources are exhausted and you're running into real problems, the California Underground Facilities Safe Excavation Board is the regulatory body in the state. So they are the ones who are tasked through law to essentially make sure that not only the operator, but the excavator, even us as the one call center, are following the rules and requirements as listed in California law. So that would be the resource to reach out to. But again, we're always going to recommend that we try to foster that communication between the operator and have that relationship conversation and see if we can clear things up that way.
Just to chime in on that, there is, this is kind of like early advance notice, but there is a feature that should be coming next year that we're currently working on with Pelican. That would be a dispute button within electronic positive response, because this has become a major issue both in California and Nevada, the two areas that we serve, where excavators are claiming that locators are posting fake EPRs to buy themselves more time. So there will be a dispute button. We're currently working on how that's going to work and interact, but there will be a dispute button in the near future, sometime next year, more than likely, that if one of these come in and you know it's not true, such as the site was not delineated, but you have documents and pictures and you know it has been delineated, where you can dispute that response. And then those disputes can be obviously made viewable to the different regulators in each state to kind of curb this action. So look for more information about that next year as we develop that feature. And obviously we'll be sending out more notices about that once it becomes live. Secondly, there was another question about design work and people using 811 for design work and what we can do to hold them accountable for that. As a general rule for everything, 811 is not a regulation agency or an agency that can actually take action against excavators, utility operators, anybody. We're simply, you can view us as the middleman between this process, between the utility operators and the excavators. So we can't take any action against anybody. However, we do have a new planning and design platform that was launched at the end of July. It can be found on our website, and it's created specifically for this purpose to allow the excavators to submit a planning and design ticket and gather the necessary maps, as-builts, drawings, things that they need to engineer or design their work before they submit an 811 ticket. So if you are a utility operator and you are getting some of these types of requests, what I would encourage you to do is to reach out to those excavators and make them aware of the planning and design platform, and to go about it doing that way, so that they're not submitting tickets that look like they're for axial excavation, even though they're for engineering or design work.
Nice. Sweet. Last question here we got from Matt. Looks like Nate might have been typing an answer.
Go ahead. Yeah.
I'll go ahead and just answer. So is there any conversation about excavators calling in large amounts of tickets at once? Where is it unreasonable to respond, or where it is unreasonable to respond to all tickets in the required time? Yeah, there is absolutely conversations about that. We've had conversations in our company, as well as at the stakeholder level, conversations within CARGA, California Regional Common Ground Alliance. And this, we know this has kind of been an issue as we speak to some of our utility locating partners as well. Sometimes they get overwhelmed with a lot of tickets all at once, and naturally it makes it very difficult, especially when all those tickets have 2 workday notices on them. Because as we all know, the law requires operators to respond within 2 working days. So there are conversations happening. I don't know of any process or thing that's going to police it or turn it down. I know something that we did do in the past was limit ticket size to try and curb this, to make smaller, more manageable tickets for our utility operators. The other thing we do in our presentations is we do, essentially preach or educate our excavators, not only to break up their large job sites into smaller tickets, but to also provide the actual start date and time that they want to begin. Just communicating that if we're all putting 2 workday notice tickets in the system, it's going to slow down responses for everyone, right? Because locators naturally just cannot deal with that type of volume, especially in dense areas. So we are working proactively to try and educate our excavators on that best practice, but there are further conversations going on, which is how to kind of approach this and best tackle it.
Hey, Matt, we had one more from Dutch regarding if an excavator exposes the entire tolerance zone of marked facility.
Yeah, we answered that one. Yeah.
Oh, okay.
Yeah,
All right, we're
so
good.
that was, we got that one. All right, so I'm looking at the chat. I'm looking at the questions. Seems like we've gone through them all. But again, if you have any additional questions, if there's something else that comes up later, please reach out to us. You know, as Nate mentioned, we are here to help you. We want to make this process as easy and as simple as possible. We care about you guys digging safely. We care about you guys having your jobs done on time. So any questions you have, any feedback, please reach out to us. We're always available. And with that, we will, like I mentioned earlier, we will make this recording available on the link that I provided earlier. That may take a couple days just to go through the footage, make sure we cut it down. Maybe there's just some fluff somewhere to make it, you know, less of a super long file type, but that will be up soon. And other than that, again, I appreciate your time that you took with us today. We went a little over, but a lot of great questions. Glad we could get through those. Anything else, reach out. But other than that, hope you guys have a great holiday and dig safe.
Thank you, guys.